Hey everybody, thanks for taking the time out of your day to join us for this webinar. I'm Brandon VanLandingham, founder of Priestess Private Wealth Management, and today's topic is estate planning. We'll go ahead and just jump right into it. Try to make this as short and sweet as possible, but we really believe that your estate plan should be the foundation of your overall financial plan. From there, once you get your estate plan in place, then you start looking at retirement and financial planning, tax strategies, risk management, all the way up to actually building a portfolio. Estate planning is, it's the one thing that if you don't set it up correctly, then you lose control of your assets. They become public record. There's a whole lot of stuff that we'll unpack in this webinar, but we believe we always start with estate planning. Whether you need a will or a trust, we'll kind of go over the difference between them today. So what are some of the estate planning issues? A lot of it's financial ignorance. People think that trust is just for super wealthy people, but in reality, it's just people just don't know what they don't know. It's not. Don't mistake ignorance for stupidity. It's just if you don't know, then sometimes you'll make the poor decisions or based off believable misinformation that's out there, especially if you're Google searching. Some things you'll get so many contradictory statements or articles about it. Wrong attitudes and poor planning. But stewardship, it requires proper planning. And the wrong attitudes portion of it really, it's not so much a bad attitude, it's just, I'm young, I don't need to worry about this now. But we all know that, we can't really guarantee tomorrow. So why should you do estate planning? Well, first of all, it provides confidence, knowing that your overall financial house is in order. Could potentially reduce unnecessary taxation and litigation, especially going through the probate process. And you really have three basic choices. You can do nothing, you can draw up a will, or you can create a revocable living trust. And we'll hit on all of these throughout the presentation here. So if you die with a will or a trust, you get to direct who gets what, when they get it, and how they get it. You control it. We even say, control it from the grave. You set it up and your wishes will be followed by your successors. But a living trust takes it a step further. It avoids probate, which that's probably the number one thing that people jump to when they think about a trust. It's like, well, it avoids probate, but there's a lot of other benefits to it as well we'll get into. But minimizing estate and inheritance taxes, it is private, whereas a will and the probate process is public record, and it's very difficult to challenge successfully. So how can you lose it all? All your stuff, home, vehicles, investment bank accounts, business. It's really because of not properly setting up your estate plan. So there's all different factors through it, succession, which is your estate plan. That's what we're going to talk about today. But then, asset protection planning against lawsuits, and also just economics, the tax planning component of it, whether it's, if your estate is large enough, there could be taxes on that. You're above the estate tax exemption limit. But here are some inescapable facts. We are all going to die. We can't take any of our earthly possessions with us. There is no U-Hauls allowed in heaven. There are no U-Hauls allowed in heaven. And someone else is going to give away all your possessions. That's just how it's going to be. And the sooner you just kind of deal with it, then I think the better off you'll be in the long run. So we won't really get into this unrealized appreciation right now. We'll talk about that here in just a minute. But the probate process, really what a will is, it's a letter to the court that explains your wishes. So here's kind of the process. You got to find it, you got to file it with the courts. It's got to be pretty much proved that this is your wishes or were your wishes. Inventory everything, appraise everything, make a notice for creditors and even claims of, like, you need to receive payments, order of distribution, and then finally you get to distribute that to your heirs. So at the end of the day, what you really want to do is you want to get all your stuff to your heirs, and there is that little thing called probate. And what a lot of people don't realize is that 66%, and this is an old statistic, I'll update that at some point here soon, but the majority of probate, let's say, is on the living side of probate. And what that means is if you become incapacitated and can no longer make those decisions, then your heirs or even your successor will have to step in, go through the probate process in order to fulfill, whether it's selling a house or selling a piece of property, and which we'll get into an example. But then the other side of it, of course, is the death side. But a lot of people overlook the living side of probate. And so let's say you became incapacitated, got in a car wreck or something. Your house is in joint tenants with rights of survivorship with your spouse. And let's say for whatever reason, she needs to sell the house. And I have no idea why in that picture she looks excited. But she needs to sell the house. Can she sell the house? And the answer is no. She would need to go through the living side of probate in order to do that. And there's other problems that come along with joint tenants. Number one, let's say that you have an adult child and you come in to me and you say, hey, Brandon, I really don't have a lot of stuff. I just have my house and my car. And I was thinking about just putting, my adult child on as joint tenants with my property. And one thing that does is, number one, it creates a gift. Number two, it opens up your assets to their creditors. So if, let's say, they had credit card mania and the credit card companies are coming after them, they could potentially come after your assets as well. There's also federal estate tax issues with gifting, and then you lose the step up in basis. So let's say you bought your house for $30,000. You put your adult child on the title as a joint tenant, and then you pass away. Well, they go to sell the house for $100,000, then they're going to owe capital gains tax on that $70,000. So they lose that step up in basis. Whereas if they were to inherit the property, and when they inherited it, it was worth $100,000. They go to sell it for $100,000. They pay no capital gains tax. So then there's the probate, the death side. So the cost, AARP says around 10%, but in the state of Oklahoma, it's really whatever's reasonable. There's delays in it. It takes, on average, I've seen 18 months is pretty typical, but it can definitely go a lot longer than that, depending on the complexity. Emotional impact that it has, you're trying to grieve, and yet you've got to settle an estate at the same time. It becomes public record. So, short story here, there was a guy, this has been, probably 15 years ago, that was caught, and he was robbing houses. And what he actually did, they come to find out, is he was actually looking at the public records, seeing who passed away, what all they had, and then was going in and robbing them. It's also, the probate process is contestable, which just means you had your wishes kind of laid out. This is what I want to do. And then, one of the heirs comes in and says, no, that's not what they wanted. And then it, again, creates delays, and it is contestable. If you owned an out-of-state property, such as a cabin in Colorado, then if that is not titled into a trust, or if you just leave it as in a will, then your heirs will have to go through multiple probates, not only in your home state, but also wherever that out-of-state asset is. And then you really lose control. Control moves to the courts. So back to that two types of probate. The main thing here is if you create a revocable living trust, then it bypasses the probate process. It's really what we call the power of the pen. You set up your trust document, your trustees, and then your successor trustees. And if anything were to happen to you, the power of the pen moves to them, and they're able to carry on regarding your wishes even after you've passed away or become incapacitated. So then there's a lot of jargon around revocable living trusts, and sometimes it can be confusing. So I made a little grid here, and a lot of times you'll hear grantor, trustor, creator. They're the ones that create the trust, and typically that's the husband and wife. The trustees of the trust who manage the trust, again, that's typically husband and wife. Beneficiaries, they are the first in line beneficiaries, so they're also listed as beneficiaries, but that's also the husband and wife as well. Then you have remaining beneficiaries. That's typically going to be your heirs, any charitable organization, things like that. And then you have what's called successor trustees or a successor trustee, and that is a job title, and their role is to distribute the trust. A lot of the times that's going to be children or a trusted friend. Some people even go with a corporate trustee, like a trust department at a bank, in order to be their successor trustee. Beneficiary designation. So one thing, if you have life insurance, annuities, retirement plans, if it has a beneficiary designation tied to it, then it bypasses the probate automatically. And depending on your circumstances, and there's a lot of pros and cons, some people will set up life insurance or annuities as where the beneficiary is actually the trust. And there's pros and cons to doing that. And again, each individual person needs to take that into consideration. Here's just kind of an update on the unified estate and gift tax. So you can see here these estate tax exemption amounts in this grid here. They started out in 2002 at about $1 million. It's now in 2024, it's $13,610,000 is an estate tax exemption. So for a lot of people, they're like, well, I'm fine. I don't have to really worry about that. But pay attention to 2025. There's a sunset provision, and if Congress doesn't act, then it'll pretty much cut it in half, the estate taxes. So if you have a $10 million estate, then it's time to reach out to your advisor and start trying to figure out, okay, what can we do now that we're actually above that exemption amount, and how can we minimize those inheritance or estate taxes? So here's some of the documents that you'll need, and this is again on the Revocable Living Trust. So you'll have the actual trust document, and then what we call essential documents are your durable power of attorney for finance, durable power of attorney for healthcare, living will, and pour over will. So those are not really the trust document. Those are essential documents, but that's if you become incapacitated, depending on how your durable power is structured. If it's a springing power, that just means if two healthcare physicians deem that you are incapacitated or unable to make decisions, then that durable power springs into power. So you can also set it up to where it's just a durable power. You sign off on it, and that lets someone else make those decisions. But what we typically do is a springing power. If something happens during a car wreck, two physicians say, yeah, he can't make decisions, she can't make decisions, then it springs into power. Then whoever you have designated as your durable power will be able to make those decisions and kind of carry on for you. And then there's a lot of issues around funding. When you say like, you create the trust, then you got to fund the trust. For a lot of people, they think, well, so I got to put money in it? How does that work? And it's like, no, really what we're talking about is just retitling your assets. So what we typically do is we'll take one of our business cards, put your trust name, when you created it, the trustees of the trust, and laminate that together so that if you're ever opening a new bank account or buying a car, you can just say, here, title it this way, put it in our trust, and here's a memorandum, which is really just a summary of your trust document, and they'll be able to title that into the trust for you. So why would you want to create a living trust? Well, first of all, it avoids probate, which that's probably the biggest reason to do it for most people, but it also avoids conservatorship, provides the durable power, your essential documents, and also provides guardianship for your minor children. So the other things to it, your family maintains complete control and privacy. It can minimize the federal estate taxes that we talked about earlier. It does not require a separate tax return. There's no maintenance fees once you create the document. Unless you want to amend it, then that will typically cost you a few $100s to amend the trust. But there's no ongoing maintenance fees. You just have to make sure everything stays titled into it. Again, if you sell a car and buy a new one, you want to make sure that new vehicle is titled into the trust name when you get the title. And it also provides confidence. So you just know that, if something were to happen to me, my wishes are going to be carried out. If I pass away, this is how my estate's going to be distributed. So again, it's not just for the wealthy. And then here's just like the cost of dying without a trust. This is where it really makes sense for a lot of people. Let's just look at that bottom row. If you had $1 million in your total estate value, Oklahoma is one of the few states that actually probates vehicles. So those are added to your estate as well. But at a 5%, which we saw the ARP was 10, but even at 5%, you had $1 million estate, then probate's going to cost you around $50,000 and up in the fees to go through probate. So if you compare that to the cost of creating a trust, then you can definitely, there's no way that a revocable living trust is going to cost you $50,000. And then not to mention the essential documents, not just the probate, it's the peace of mind of, if I'm ever incapacitated, or if I just decide that I'm unwilling to continue on, like whether it's financial, paying bills or something like that, I can just sign this, power of attorney and have them handle that for me. For us, we utilize software to do this, so we'll walk clients through it. And even if you went to an attorney that charged $3,000, $5,000, $6,000 for a trust, it's still worth the cost. For our clients, we're typically right around $1,000 to create the trust. And again, it depends on complexity and if there's any issues that we need to bring in an outside attorney for. But still, it's just kind of a no-brainer when it comes to the probate cost. And then here's pretty much the steps to establish a trust. You determine what your objectives are. What are your goals? How do you want your estate to be distributed after your passing? Identify the assets, gather data, which we pretty much walk through a checklist with you. Then the document gets drafted. Then we'll sit down and execute the trust document with you. You'll have to bring 2 unrelated witnesses to execute the trust document. And then we'll walk you through the retitling of the assets and putting those into your trust. The funding process is what we call that. So we'll help you get your car titles, your deed, bank accounts, all that stuff titled into the trust name. So for us, that is the foundation. And then from there, we kind of walk through a process of, then let's do some of the other planning, whether it's retirement, business succession planning, or just general financial planning. We'll go through risk management, cash management, and of course, all this ties into a properly structured and designed portfolio, your investment accounts. After we get the trust document or the estate plan set up, then what are the things that we need to build on that from? And these are the steps that we typically walk through. So here's a poem that an associate of mine actually brought to my attention years ago, and it kind of always stuck, so I thought I'd throw it here at the end of this presentation. It's called Tomorrow, and all men think all men mortal but themselves. That was Edward Young. But pretty much the poem just says, I'll just read it to you. He was going to be all that a mortal could be tomorrow. No one would be kinder or braver than he tomorrow. A friend who was troubled and weary he knew, who would be glad to give glad of a lift, and who would need it too, on whom he would call and see what he could do tomorrow. Each morning he stacked up the letters he would write tomorrow, and he thought of the folks he would fill with delight tomorrow. It was too bad indeed he was busy today and hadn't a minute to stop on his way. More time I'll give others, he'd say, tomorrow. The greatest of workers this man would have been tomorrow. The world would have known him had he ever seen tomorrow. But the fact is he died and he faded from view, and all that he left here when living was through was a mountain of things he intended to do tomorrow. So that's just kind of the poem to say, hey, don't procrastinate. Whether you need to reach out to an estate planning attorney, or you have questions and you want to reach out to us, no problem. If you need any additional information pertaining to your specific situation, you can send us an email, give us a call. You can also go online to our website, which is parisisprivatewealth.com. Should be down in the description below. And then you can schedule either a phone call or a no-cost consultation. And again, it's confidential appointment. Everything is private. And we can answer any of those questions for you, but would be happy to help you set up what we consider the foundation of a properly structured financial plan. So until next time, guys, choose your advisors wisely. Your financial health depends on it.